All right, well, good afternoon, everyone. Hope you're having a good week. Hope you had a good Labor Day weekend. And we are back now for, I guess, what is week three. It's kind of hard to believe we're already in week three, but technically we are. So, just a couple of really quick reminders. Coming up due next Monday on the 11th, you have two items that are due, and I know some people have already turned these in. If you have, thank you very much. Otherwise, if you have not yet, then they are due by Monday. Those two items are your initial skills self-assessment. And again, with that initial skills self-assessment, just remember it's an honest assessment of how comfortable you are in those different areas of the program and what type of experience you have in those five core content areas for the MPA program. And then finally, what you hope to get out of the program. Again, if you are not in the program, you're in this course, but you're not in the MPA program, then for that third part of the initial skills self-assessment, just kind of tell me what you would like to get out of being in this PPA 500 course. So it is an honest assessment. There are no right or wrong answers, so you don't have to worry about that. But that does need to be then submitted to the Dropbox no later than midnight next Monday. And then you also have Canvas essay number 1, which is this discussion of James Madison's Federalist Paper number 10. Your initial post, a couple of paragraphs should suffice for that. And then you should also respond to at least 2 classmates, and each of your responses to classmates can be much more brief. They can be a paragraph each, and that certainly will be sufficient. So those are the 2 assignments that you have due then next Monday by midnight on September the 11th. So that's just a reminder for you. I know, again, as I said, some people have already completed them, but please do have those completed and submitted by 11:59 p.m. on next Monday. So where we are right now in the class is obviously we have worked our way up to a discussion of the Constitution. The last time we were together, we talked a lot about the foundational elements of American government. We talked about social contract theory. We talked about separation of powers and federalism, talked through the development of federalism, talked through the idea of power in our system of American government. And what I told you last week is where I would like to start this week is with a discussion of the Constitution as our social contract. And I know we're a little bit early for Constitution Day. If I'm not mistaken, I believe Constitution Day is scheduled for Sunday, the 17th of September. I believe this year it's always around the middle of September. So we're about 2 weeks early to celebrate the Constitution. But it is important for us to go through and understand the different elements of the Constitution and what the Constitution means for us as public administrators. So in the first half of class tonight, we'll walk through the Constitution, not covering every single word of the Constitution, obviously, but going through all 7 articles, going through the 27 amendments, and talking about what they mean and how they have shaped the political environment in which we operate as public administrators. We'll then take a break. Then the second half of class, we will turn our attention to the topic of accountability and ethics. We'll talk about accountability in public administration. We'll talk about why sometimes it's difficult for us to implement ethical standards in the public sector. We'll talk about some of the major differences between ethics in the public sector versus ethics in the private sector, and kind of what we call this shock of ethical upgrade that sometimes people feel when they move into the public sector. We'll talk about trying to balance accountability with effectiveness, because we want to be accountable because we're spending public taxpayer money, but we also want to be as effective, as efficient as possible in spending that money and achieving the goals of the programs that we are trying to achieve. And then I'll take you through the ASPA, American Society for Public Administration, the 8 principles in the ASPA Code of Ethics, talk about those and what may be difficult sometimes in terms of implementing some of those 8 ethical standards. So first half of class tonight, Constitution, second half of class tonight, accountability and ethics. But before we jump into our discussion of the Constitution, are there any questions or any need for clarification before we get into our discussion?
Hi, this is Lauren. Quick question for the replies to the 2 other student discussion topic. Is that due at the same time? So everything's due that Monday, or the discussion or the replies due at a later time?
It's a great question. They're all due no later than midnight on Monday, the 11th. I do encourage you, though, for the initial post, if you can post your initial post earlier than that, then people have something to respond to. If everyone waits and posts their initial post on the day it's due, then it's difficult. People are scrambling around to try and respond to something. So they're all three due by September 11th. But if you can post your initial post, maybe by Thursday, Wednesday, or Thursday of this week, that gives someone something to respond to, and we'll have a more robust discussion.
Got it. Thanks.
Sure, great question. Any other questions or clarifications?
I had a quick question.
Mhm.
For the assigned readings, we were assigned a Bennington and Moore article, and I was unable to find where that was.
Yeah, that one is in the classics textbook. Let's see if I have my copy here. I may not have the copy with me, but it's the number may be wrong. It's either 54 or 55, but it is in the classics textbook. It's by Bennington and Moore, so it's in that classics text.
Oh, okay. Okay. Got it. Thank you.
Sure. Okay, well, buckle up for our discussion of the Constitution. Again, you can have an entire class on the Constitution. If you know anyone who went to law school, you know that constitutional law tends to be an entire year of looking at the Constitution in cases where the Supreme Court and other courts have interpreted aspects of the Constitution. So what we're going to do tonight is we're just going to kind of hit the tip of the iceberg and just cover some of the basic elements of the Constitution that is necessary to function within our environment of American government. So we're not going to get into a lot of the details, a lot of the nuances, but I do want to highlight some of the parts of the Constitution that are topical today, because we're talking today about things such as Section 3 of the 14th Amendment and what that means then for qualifying for the ballot. And so there are some aspects of the Constitution that certainly are alive and well in public discourse today. So we'll highlight those issues as well as we go through our discussion. One thing we do know about the Constitution, well, a couple of things we know. One thing we know is that, as we said last week, the Constitution is a series of compromises. It's a series of compromises between large states and small states, between slave states and non-slave states, between federalists and anti-federalists. And those compromises are embedded throughout the entire Constitution. And whenever you have a constitution, a social contract that is predicated upon compromises, you are going to have some ambiguities. You're going to have some discussion, certainly, over the ensuing years about, well, what did the framers mean when they said a well-regulated militia in the Second Amendment? Or what did the framers mean in Section 3 of the 14th Amendment when they talked about providing aid and comfort to an insurrection or a rebellion? What exactly did they mean? And some of what the framers meant come to us from the interpretations of the judicial system, most prominently the Supreme Court. But a lot of the other interpretations can come to us through the other writings of the framers. Now, in this class, I only really assigned you 2 or 3 Federalist papers to read, but as you know, there are 85 Federalist papers. If we really want to know what the framers meant by what they're saying in the Constitution, we can find out because they told us, and they told us in many of those Federalist papers. Now, the Federalist papers were written as kind of a sales pitch, as we had said last week, to the anti-Federalists and to the citizens of New York who were concerned that this Constitution created too strong of a national government. So I think there's some validity in saying that sometimes with what the framers wrote in the Federalist papers, they were kind of overemphasizing that the Constitution is nothing to be afraid of. And they were certainly trying to convince the constitutional naysayers. But it's still interesting to read those Federalist papers and really kind of glean what the framers really did mean by some of the phrases that they used in the Constitution. And as we go through the Constitution, I'll point out some of those Federalist papers that are kind of good supplementary reading for some of the passages here in the Constitution. So number one, the Constitution is a series of compromises. The second thing to know about the Constitution is it is a very well organized document in that there are 7 main articles in the Constitution, and each article speaks to different topics. So Article 1 talks about the legislature. Article 2 talks about the executive. Article 3 talks about the judiciary. And so it is a relatively well-organized document. So let's start out with Article 1 of the Constitution. Article 1 talks about Congress. Article 1, Section 1 lays out this bicameral Congress, where we'll have a House of Representatives and we'll have a U.S. Senate. This is your Connecticut Compromise, your great compromise between the large and small states that we talked about last week. Then in Article 1, Section 2, the framers get into a specific discussion of the House of Representatives. And when you look at the 7 articles of the Constitution, you'll see that Article 1 is by far the lengthiest, and it's also the most detailed article in the entire Constitution. The framers put a lot more specifics into Article 1 than they put into any of the other articles. So in Article 1, Section 2, we have some specifics about this House of Representatives. We know that this House of Representatives will be popularly elected. We know that members of the House of Representatives will serve very short 2-year terms, and the purpose of a 2-year term is to keep them as accountable to the people as possible. So this is your lower house of Congress, very closely tied to the people. We place an age limit on your ability to become a member of the House. You have to be at least 25 years old. You must be at least 7 years a citizen of the United States, and you must live in the state in which you are being elected. You have to live in the state in which you're being elected. So it's not necessary that when you're running for a seat in the House that you live in your district, although obviously for political reasons that would be advantageous, but you must live in the state in which you are being elected from. The next paragraph in Article 1, Section 2 has been replaced by subsequent amendments. And in Article 1, Section 2, this third paragraph, this is where we talk about the apportionment of representation and the apportionment of taxes. So this is where we get the 3/5 compromise, that compromise that was embodied in the Constitution to try and balance the interests of slave and non-slave states. That obviously has been removed, that's been replaced by the 14th Amendment, but under the original Constitution, for purposes of representation, people who were enslaved would count as 3/5 of a non-enslaved person for the purposes of representation in the House. Also here in Article 1, Section 2, we say that vacancies occur in the House, that you will have those vacancies filled by executive appointment, meaning governors in the state would then have the opportunity to fill those vacancies. Now, every state has their own set of rules about how close to an ensuing election does it have to be in order to have the governor make the appointment as opposed to waiting to an election. We have one vacancy currently in the House of Representatives, and that's a representative from Rhode Island, David Cicilline. He stepped down from his seat to become the I think it's the chairperson of the Rhode Island Foundation. And so his position is vacant. We're going to have a special election in Rhode Island in November to fill that seat. We have another seat that will be coming vacant as of next Friday, and that's Christopher Stewart, who is a representative, Republican representative from the state of Utah, the 2nd District in Utah. He is stepping down for family reasons. His wife is ill. And so he'll be stepping down as of next Friday. And then in November, there'll be a special election to replace him. So we have one vacancy, soon to have 2 vacancies that will both be filled through special elections in November. Also in this section, or at least in this article, we talk about the offices in the House of Representatives. There is one constitutional position in the House, and that constitutional position is Speaker of the House. It is a constitutional position, so it is something that's required by the Constitution. Current Speaker of the House is Kevin McCarthy, a Republican from California, and that is a constitutional position. that is a constitutional position that you'll see as you read through the Constitution, places that person in direct line to become president if the president's incapable of holding their office and the vice president's incapable of holding the office, then the third person in line would be the Speaker of the House. The House then has the ability to appoint its other officers, and it has done so. And so you have a variety of offices within the House of Representatives that are not necessarily constitutional positions, positions such as majority leader, positions such as minority leader, majority whip, minority whip, regional whips. There are a lot of different positions, committee chairpersons, subcommittee chairpersons, a lot of other positions in the House that are not constitutional. They're not spoken of in the Constitution. And then we all lived through the last administration and the two impeachments that occurred in the last administration. So we're all familiar with the fact that the House of Representatives has the sole power of impeachment. So the House of Representatives has the ability to pass what are called articles of impeachment. It only has to be done through a simple majority vote. And then once those articles of impeachment are passed, then they are sent over to the Senate, and then the trial gets held in the US Senate. But it's only a simple majority to pass these articles of impeachment. We saw it done in the Clinton administration. We saw it done twice in the recent Trump administration. And there are rumblings you've probably seen in the House now that the Republicans are moving toward an impeachment inquiry that would eventually lead to voting on articles of impeachment for President Biden. So it's becoming much more frequent that we see this impeachment power being used by the House. Then in Section 3, we get into the US Senate. The Senate was designed differently than the House of Representatives. Whereas the House was designed to be very closely related to the public, 2 years terms, being popularly elected, the Senate was the upper house. And so as the upper chamber, members of the Senate have to be older. They have to be at least 30 years old in order to serve in the Senate. They serve a term of 6 years as opposed to 2 years, which again insulates them from public pressures and public sentiment. And under the original Constitution, they were not popularly elected. Members of the Senate were selected by the respective state legislatures. So there was no direct popular election of the Senate in Section 3 of Article 1. The Senate is broken up into thirds, and so that every 2 years, a different third of the Senate will be up for election. So you won't have all 100 senators all coming up for election all in year 6. It's staggered, 1/3, 1/3, and 1/3. So we said you have to be at least 30 years old to be a senator. You have to be 9 years a citizen of the United States, and you have to be an inhabitant of the state from where you are being elected. The vice president serves as the president of the Senate, but has no vote unless the Senate is equally divided. And we've seen this where Vice President Harris has come over to Capitol Hill and has cast a deciding vote. Sometimes Vice President Harris has come over expecting to cast a deciding vote, and then it's not a tie, and then she goes back without having to cast a vote. But the Vice President only votes in the case of a tie. That's important today because the Senate is very closely divided along partisan lines. It's essentially a 51-49 division, 51 Democrats, not technically, but 51 Democrats, 49 Republicans. And I say not technically because 2 of those senators who are counted on the Democratic side, actually now we're up to 3 that are counted on the Democratic side, are actually independents. And so you have Bernie Sanders from the state of Vermont. He caucuses with the Democrats, but he's not officially a Democrat. He's listed as an independent. Angus King from the state of Maine also caucuses with the Democrats, but is not a Democrat, is considered an independent. And now recently, Kristen Sinema from the state of Arizona recently left the Democratic Party. She is now considered an independent, although she routinely caucuses with the Democrats as well. So functionally, for voting purposes, it's technically a 51-49 split, but it's a very tenuous majority for the Democrats, not only because of those 3 members who are now independent, but also other members such as Joe Manchin from West Virginia, who is considered a very conservative Democrat. He still considers himself a Democrat, but he oftentimes works with and co-sponsors legislation with Republicans. And so getting those 51 votes cobbled together by the majority leader, Chuck Schumer, is very, very difficult compared to how it has been in the past. So it's a very close partisan divide in the Senate, which then increases the possibility of the vice president needing to cast a vote to break a tie. You should also mention over the House, it also is very closely divided along partisan lines. It's 222 Republican seats, 212 Democratic seats, and then one vacant seat, which, as we said, is Rhode Island's David Cicilline's seat. Very soon, though, so we have that one vacancy. Very soon we'll have two vacancies, and that Chris Stewart is going to be stepping away. So it'll go from 222 to 221 Republicans compared to 212 Democrats. So again, very close type of partisan alignment, or very close in terms of partisan composition of the House as well as the Senate. And just as a side note, we're not going to go through the California Constitution in this class just because it is so incredibly lengthy. California has probably the world's longest constitution. The California Constitution has been amended over 500 times. But it is important to note that our state legislature is also bicameral and kind of matches the bicameral approach at the federal level. We have a California State Assembly and we have a California State Senate. The California State Assembly currently has 80 members. Of those 80 members, 62 are Democrats. So 62 Democrats and only 18 Republicans. So it goes beyond even what we consider to be a supermajority. It's almost 80% Democratic. And in the California State Senate, we have 40 seats. So the state Senate is half the size of the state assembly. We have 40 seats in the California State Senate. 32 of those seats are Democratic and 8 of those seats are Republicans. So you have about an 80% Democratic majority in the California State Senate. So whereas you have a lot of divisions in terms of the House and the Senate at the federal level, you have very much one party rule here in California in both our assembly as well as our state Senate. But to get back to the discussion of the U.S. Senate, just like with the House, the U.S. Senate gets to choose their own officers. The one constitutional position here is President Pro Tem of the Senate. President Pro Tem of the Senate usually is the longest serving member from the majority party. So longest serving member from the majority party is the President Pro Tem. Whereas the House has the power to impeach presidents, the Senate has the sole power to then try those impeachments. So just because you have been impeached by the House does not mean that you're going to be removed as president. You then have to go through a trial in the Senate. And we saw 2 of those trials happen in the past administration. And it's a very interesting process. If you watch either of those impeachment trials, there are a lot of formalities, and a lot of those formalities come directly out of Article 1, Section 3 here of the Constitution. So while that trial occurs, in order to remove a president, you have to have a 2/3 majority. You have to have a super majority of 2/3 in order to remove a president. So it's very easy to impeach a president in the House with a simple majority, but you have to have a 2/3 majority to remove that president, which is incredibly difficult to do. And we saw that in the last 2 impeachment trials. Senators have to take an oath, and if you watch the impeachment trials, you saw one of the first things they did is they all had to gather together into the Senate chambers, and they all had to stand up and they all had to take an oath that they would be impartial jurors in this trial. And the trial is then headed up by the Chief Justice of the Supreme Court. So John Roberts presided over the 2 trials of President Trump. William Rehnquist, at the time back in the 90s, presided over the trial of President Clinton. We have never had a situation where a president has been removed through an impeachment trial. We have had judges and justices removed by the Senate. We have not had a president removed. President Trump was not convicted in his 2 trials. President Clinton was not convicted in his trial back in the 1990s. The closest we came was Andrew Johnson. And Andrew Johnson was impeached by the House, was tried in the Senate. and survived removal by only one singular vote in the Senate. He was one vote away from being removed from office. That's as close as we have come to removing a president from office. You might be saying, well, how about Richard Nixon? Richard Nixon resigned, and Richard Nixon actually resigned before he was impeached. Impeachment articles had been presented in the House, and you had had the committee hearings, and the House was ready to vote on impeachment. A group of Republican senators on the eve of that impeachment went to the White House and essentially told President Nixon, you do not have our support. And if the House impeaches you, we will vote to convict you in the Senate. And at that point, Nixon really had no choice except to resign his presidency. So he resigned before he could be impeached. Another important thing here with impeachment is that in this last paragraph of Section 3, the framers put in a clause saying that judgment in case of impeachment shall not extend further than removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. That's as far as it extends, that you can, if you're found guilty of these charges in your impeachment trial, you can be removed from office and you can be disqualified from ever holding office again. Now, in the first Trump impeachment trial, there was a lot of discussion about, can those two clauses be severed? Is it possible to remove a president from office, but then not disqualify that person from seeking other offices in the future? The answer is kind of murky in that the Senate has done it both ways. When the Senate has removed some judges from office, they have disqualified them from ever holding office again. In other situations, they have merely removed them from office, but they have not disqualified them. So in the past, they have severed those two clauses, but that was a big question mark in the Trump impeachment trial. It became a moot point because former President Trump was not convicted during his impeachment trial, either of his two impeachment trials. So Article 1, Section 4 then talks about elections. Elections are determined by states, but Congress can come in and make changes to how those elections are held. But elections are essentially one of the main functions in our federalism system of state governments. And so states control their elections. Let's see, what else do we have here? We have each house is able to establish their own rules, and so they do have different rules. When you look at how the House of Representatives operates as compared to the US Senate, you'll see that they operate very, very differently. The House is very regimented. It's a very strictly controlled process, how legislation is considered in the House. The Senate is a much more we call egalitarian, collegial type of a situation. In the House of Representatives, if you're a new member of the House of Representatives, you don't have very much power at all. You're what's referred to as being a backbencher. And so typically, if you're a new member of the House, when you request your committee appointments, you're not going to get the most plum committee appointments. Chances are you're not going to get on Ways and Means. You're not going to get on Foreign Affairs. You're not going to get on judiciary, a lot of these very important types of committees. And that's because power flows from the top in the House of Representatives. How legislation is considered is also very strictly controlled. In the House of Representatives, we have a committee called a Rules Committee. And that Rules Committee will determine what legislation gets to the floor and how that legislation will then be discussed and debated once it makes it onto the floor of the House. No legislation, for the most part, I'll say, I won't say no, I'll say the vast majority of legislation, in order to get to the floor of the House, must first go through this Rules Committee. And the Rules Committee must pass a rule to allow that legislation to go to the floor for consideration and eventual vote. That's much different than the Senate. In the Senate, the Rules Committee is a different type of committee. For a piece of legislation to get to the floor of the Senate, it does so through what's called a unanimous consent agreement. And I'll try and type and not misspell while I'm talking. A unanimous consent agreement, or a UCA. In essence, one single senator can stand up and at least temporarily stop the consideration of a piece of legislation. And we have seen that recently. Senator Tuberville from the state of Alabama has stopped legislation that would appoint military officers. And he's been able to logjam all those appointments. Senator Rand Paul from Kentucky has done a similar type of thing in other policy areas as well. So you might say, if you have to get unanimous agreement, how do you possibly get anything to the floor? And the reason why you can get legislation to the floor, even with unanimous consent agreements, is that most senators understand that if I support your legislation, you're going to support mine. So if I block your legislation, you're going to block my legislation. And so it's kind of like this quid pro quo, where I will let your legislation get to the floor and you will let my legislation get to the floor. It's a process in Congress that is known as log rolling. You help my legislation, I will help your legislation. So it's not usually all that difficult to get legislation to the floor of the Senate. Once legislation gets to the floor of the Senate, debate is technically unlimited in that a member can just filibuster. They can get up there and they can just talk forever to keep a piece of legislation from being passed by the House. In order to stop a filibuster in the Senate, you need to get this thing known as a vote of cloture. And a vote of cloture requires a vote of 60 senators to agree to stop the filibuster and then consider and vote on the piece of legislation. So that's why sometimes you'll hear people say, in order to get something through the Senate, you don't need a simple majority, you need a vote of 60, because it takes 60 votes in order to get a vote of cloture to stop a filibuster and actually pass a piece of legislation. In the House, there is no such thing as filibustering. In the House, debate is very strictly timed and controlled. If you ever watch the House on C-SPAN, you'll see this. Members will get up there and they'll say, I would like to yield 2 minutes to the gentle lady from the state of California. That representative will get up and literally have 2 minutes to speak. Once those 2 minutes are over, then it's someone else's turn. And so the Democratic leader controls the time for Democratic members. The Republican leader controls the time for Republican members. So it's a very strict, very regimented process in the House, a much more egalitarian, collegial, debate-driven process over in the US Senate. So the two really do operate much differently and have different rules. Both the House and the Senate maintain a journal, and you see that also here in Article 1, Section 5. The journal is important because the journal is the recording of what went on in the House or the Senate in that given day. And again, if you watch debate on C-SPAN, you'll sometimes see members will start their speech by saying, I ask the right to revise and extend my remarks. Whenever they say they want to revise and extend their remarks, they may only have 30 seconds to speak on the floor of the House, but by revising and extending the remarks, they then get permission to put everything they want to say into the congressional records. They can put everything they want to say into the House Journal for that day, even though they only have 30 seconds to actually say it on the floor of the House. Section 6 of Article 1 talks about compensation, that members of the House and the Senate can be compensated. Now, this has been slightly changed as a result of the 27th Amendment, but we will get to that in a little bit of time. Also talks about you can't hold another civil office in the United States while you are a member of the House or the Senate. Also says that you cannot benefit from what are called emoluments. Emoluments are any type of money or any type of benefit that you can accrue from your public office beyond your compensation, beyond your salary. This emoluments clause applies to members of Congress. The emoluments clause also then in Section 2, Article 2, applies to the presidency as well. And that was a big point of controversy during the Trump administration, whether or not former President Trump was getting emoluments, was getting additional compensation from his hotel in Washington, D.C., and from some of his other business ventures. Also here in section 6, there is a protection given to members of Congress against being sued for what they say on the floor. So what they say on the floor of the House or the Senate is immune then from any type of prosecution. So they cannot be held liable, they cannot be sued for what they say on the House or the Senate floor. And moving on down to Article 1, Section 7. Here's a very important part of Section 7, right at the very beginning of the section. All bills for raising revenue shall originate in the House of Representatives. So any bill that deals with raising revenue must start in the House of Representatives. And again, that was done intentionally by the framers because the House was closer to the people. And so they thought people would be most concerned about anything that costs them money. And so if Congress is going to raise taxes, that should start in the House so that people can hold those members of the House accountable in being popularly elected and serving only 2-year terms. We also know before the president can consider a piece of legislation, that piece of legislation must pass the House and the Senate in identical version. So what that has created is created kind of a cumbersome process whereby if a piece of legislation is passed in the House of Representatives, and typically what will happen is a bill will get introduced. Once that bill is introduced, it will then get numbered and it will then get referred to a committee. The committee will then probably take that piece of legislation and refer it to one of its subcommittees. The subcommittee will then consider that legislation, will make amendments to that legislation, will probably hold hearings about that legislation, and will then pass the version of that legislation from the subcommittee level back to the parent committee. The committee will then look at that bill that came out of the subcommittee, will then hold their own hearings, will then make their own modifications and amendments, and will then pass that bill. Once the committee has passed that bill, typically that bill then has to go to the Rules Committee, as we discussed earlier. The Rules Committee will then pass a rule governing when that bill goes to the floor and how that bill will be discussed and what types of amendments will be allowed once that bill goes to the floor. Some bills, once they go to the Rules Committee, are considered to be privileged pieces of legislation. So oftentimes appropriation bills in the budgeting process will be considered to be privileged legislation. As privileged legislation, the Rules Committee will probably not allow much debate or maybe not even any amendments to that bill once it goes to the floor of the House. If it's non-privileged legislation, then they will allow debate, they will allow amendments. Then once that rule is passed by the Rules Committee, then whenever that bill is due to come to the floor, it will come to the floor of the House. It will then be debated at the floor of the House. Amendments may or may not be able to be added to that bill on the floor of the House. And then if the House passes that bill, then you got to wait and see what the Senate does. And then the Senate will go through kind of a similar process where it'll be introduced in the Senate, oftentimes go to a committee, then to a subcommittee, then back to the committee, then makes it to the floor of the Senate through a unanimous consent agreement, then gets debated on the floor of the Senate, and then gets passed on the floor of the Senate. Chances are, once you've gotten through those two processes, the House version of the bill looks much different than the Senate version of the bill. So then you have to have what's called a conference committee. Then you have a conference committee made up of members of the House and members of the Senate to hammer out the differences between the House version and the Senate version. Once the conference committee has come up with the identical version of the bill, then that identical version goes back to the House floor and back to the Senate floor for passage before it can then go to the president for the president's signature. So all bills must be in identical format before they go to the president for the president's signature. That's a very important process. It does slow down the legislation process, but it also makes sure that we have uniform legislation, that the president's not getting one bill from the House and one bill from the Senate, and then having to choose between the two, gets the same bill from the House and the same bill from the Senate. Article 1, Section 8 is by far the most famous part of Article 1 of the Constitution. In Article 1, Section 8, we lay out the powers of Congress. And this is where we do this process known as enumeration. Enumeration is a listing of the powers that belong to Congress. And as we talked about last week, whenever you enumerate powers, whenever you list powers, you are by definition limiting them. Because the assumption is if a power is not enumerated, if a power is not listed, then that power does not belong to Congress. So this is very much a nod to the anti-federalists. We're going to only have a certain set of powers and duties that will be afforded to the Congress. We will list them specifically in Article 1, Section 8. So some of the enumerated powers that you're very familiar with, the power to levy and collect taxation, the power to borrow money, and Congress is very, very good at borrowing money, the power to regulate commerce with foreign nations and among the several states and with Indian tribes. This is a very important power. This is what's referred to as the Commerce Clause of the Constitution. And whenever Congress tries to expand its power over states in our system of federalism, one of the tools it oftentimes uses is this Commerce Clause, the ability to regulate commerce and trade between the states. This is what's known as interstate commerce. So they have the power to regulate interstate commerce. States have the ability to regulate intrastate commerce, which is commerce that occurs within their state. But once that commerce, once that trade crosses state boundaries, it then becomes interstate commerce, and that is then regulated by Congress under this Commerce Clause. So a very, very important part of Article 1, Section 8. Establish uniform rule of naturalization to coin money. Again, as we had the Articles of Confederation and ended up replacing with the Constitution, one of the problems is we had sometimes had different coinage and different currency being used. Here, Congress has the sole power to coin money, to provide for the punishment and counterfeiting of securities, to establish post offices. And so this is kind of the genesis of what we have now in our U.S. Postal Service, to establish post offices and postal roads, to constitute tribunals inferior to the Supreme Court. One very short sentence where you have their 8 words that are extremely important. By saying to constitute tribunals inferior to the Supreme Court, the framers gave Congress to create the entire federal judiciary underneath the U.S. Supreme Court. The only court created in Article 3 of the Constitution is the U.S. Supreme Court. All other courts below that were created by Congress in the Judiciary Act. So all of our courts of appeals, our circuit courts of appeals, all of our federal district trial courts, those were all created by Congress. Define piracies, to declare war. Congress is the only body that has the ability to declare war. If a president wants to declare war, they must go before a joint session of Congress and ask for that declaration of war. Presidents have done that officially twice. They did that with World War I, and they did that with World War II. In World War I, there was some pushback, and there was some disagreement in Congress about declaring war. In World War II, there was only one person in Congress who voted against the declaration of war, and that was a representative by the name of Jeanette Rankin, who, not coincidentally, also voted against the declaration of war in World War I. But presidents have to ask for that declaration of war from Congress. It doesn't mean that presidents cannot send troops into military engagements. They certainly can. But if you're actually going to officially declare a war, it's got to be done by Congress. Congress has the ability to raise and support armies. Again, this is one of the problems we had in the Articles of Confederation, is that the Congress, the quote-unquote Congress at that time, did not have the power to raise an army, did not have the power to raise a navy. That is given to Congress in this new Constitution. Other enumerated powers, you can read through those on your own. DC, creating this district whereby the capital will be located. That district is then under the control of Congress. And then once you get through all of those enumerated powers and you get to the very bottom of Article 1, Section 8, you then have this thing called the Elastic Clause. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. In other words, Congress can do anything that it considers necessary that will then allow it to carry out those enumerated powers that were previously listed in Article 1, Section 8. So you can see here is this compromise. On one side, we have a listing of specific enumeration of powers, which is a nod to the anti-federalists. But at the end of this article, of this end of this section, we have this elastic clause, where we then throw the doors wide open and say Congress can do whatever it needs to do to enable it to carry out these powers that were listed previously in Article 1, Section 8. This tension between the enumerated powers and the elastic clause, one of the great unanswered questions of federalism. And whenever Congress wants to expand its power, it does so either using the Commerce Clause we talked about earlier, or this elastic clause in its ability to make all laws that are considered necessary and proper. So here is a compromise that created some ambiguity that really creates the basis of a lot of the discussions and disagreements we have in our system of American federalism. So Article 1, Section 8 is very specific and probably the best known, and I don't know if I'll say the most important, but certainly the best known part of the entire Constitution. So if in Article 1, Section 8, we are enumerating powers and giving powers to Congress, then in Article 1, Section 9, again, as a nod to the anti-federalists, we will limit certain powers from Congress. We'll limit certain things that Congress may not do. This first part of Article 1, Section 9 was, again, this compromise that was meant to try and mitigate the conflict between slave and non-slave states. It essentially bans any laws that would outlaw the slave trade until at least the year 1808. So the 3/5 compromise in Article 1, Section 2, and this prohibition against banning the slave trade in Article 1, Section 9, those were the two compromises that were meant to try and mollify slave states to get slave states to agree to this new constitution. As we had said before, however, they really laid the groundwork for what would eventually lead up to the Civil War. Congress may not remove the writ of habeas corpus, and you're probably familiar with the term writ of habeas corpus. Writ of habeas corpus means literally to present the body. And so if someone is arrested for a crime, you can't just arrest someone for a crime and then hide them away. You have to say what they were arrested for, and that has to be public so people know you're not just kidnapping and taking people away under the guise of committing a crime. No bills of attainder or ex post facto laws may be passed by Congress. A bill of attainder is essentially saying someone is guilty without a trial. So if we say you're guilty, but we don't afford you the right to a trial, that's what's called a bill of attainder, and that was prohibited. An ex post facto law is an after the fact law. So Congress may not pass a law that applies after the fact. So you did something last year when it was completely legal, then this year Congress passes law saying it's illegal, and then they arrest you for what you did last year when it was legal. You can't do that. They cannot apply, laws cannot apply after the fact. The next section was taken out by the 16th Amendment to the Constitution. Under this original Constitution, taxes had to be apportioned according to population. This was a concession that was provided to small states. Small states were concerned that they would have to pay an equal share to large states in taxes, and obviously they didn't want to do that. So under the original Constitution, taxes had to be apportioned according to a state population. Now that again was taken out with the 16th Amendment in 1919. No tax or duty laid upon articles exported from any state, so you can't tax those articles that are being exported by states. No preference being given for the ports of one state over another. This next section is important. No money shall be drawn from the Treasury, but in consequence of appropriations made by law. This means that if Congress wants to spend money, that money must first be what we call appropriated. When you appropriate funds, you are simply saying this is how the money will be spent. That's why in the budgeting process, we have what's called appropriations, where Congress must say this money is being spent on this money is being spent on this. There are no titles of nobility that will be granted by Congress. And so, I mean, if you want to be a knight or a sir, that's not going to happen because Congress cannot make people knights or sirs. And then Article 1, Section 10, we then impose some limitations of what states cannot do. So this applies to then state governments. States cannot enter into treaties or any types of confederations or alliances. They cannot grant what are called letters of marque and reprisal. A letter of marque and reprisal is essentially governments at this point in time were paying private ship owners, what were called privateers, to go and raid the ships of other countries. And so if you were in a disagreement with England and you would pay Americans who had ships to then go and essentially be pirates and to raid the ships of England, that would be the legal standing for doing that would be what's called a letter of marque and reprisal. So no longer have those privateers going out there and attacking the ships of other countries. States cannot coin money. States cannot emit bills of credit. States cannot grant titles of nobility. So a lot of the same things are saying Congress can't do in Section 9. We're then turning around and saying states can't do them either in Section 10 of the Constitution. And there are more, but again, I know we're running long on time. So in Article 1, what we've done is we've established the structure of this bicameral legislature. We have talked about what powers and duties the House and the Senate have. We've talked about some of the powers that do not belong to the House and the Senate and some of the limitations they face. And then we've also in Section 10 talked about some of those limitations that are placed upon state governments. So in Article 1, we're essentially trying to divvy up the powers and responsibilities between Congress at the national level and sovereign state governments. So a whole lot of detail, a whole lot of specifics in Article 1. Then Article 2, the framers turn their attention to the executive branch. And Article 2 is much shorter than Article 1 and is far less detailed than what we had in Article 1. In Article 2, we talk about this position of President of the United States. We assign a 4-year term to the President of the United States. And again, the reason why we use 4 years is that closely matched a lot of the terms of governors in many of the states. And so the framers really wanted to align a lot of these terms with what was going on in the states so that anti-federalists couldn't say, well, this is a brand new thing and we're scared of it. You can't be scared of it because it's very similar to what's already going on within your own state government. We set up this system of the Electoral College, in which we have made changes to over time. But I'm sure you're probably familiar with the Electoral College and how the Electoral College works. The Electoral College is unique. It's a unique aspect of our system of American government. And the reason why we have an Electoral College, a couple of reasons. One main reason why we have the Electoral College is it was, again, protection being given to small states. We didn't want small states to have no power, very little power in the election of the president, as would happen if you had a completely national popular vote. So we create this Electoral College where states will get a number of electors based upon their representation in the House plus their representation in the Senate. So since every state has 2 senators, then that at least guarantees some representation for states in the selection of the president. So it was a nod to small states. The second reason why we got the Electoral College, many historians will argue, is because there was some inherent distrust among the framers in terms of their faith in average ordinary citizens making such a momentous decision as the election of a president. And so the idea was these electors in the Electoral College who would actually select the president, these electors would be more knowledgeable about the political system. They'd be more knowledgeable about the candidates and would then serve as a check against popular sentiment. And so there was a couple reasons why we ended up with this thing called the Electoral College. Again, as you know, the Electoral College, the way in which it works today, there are 538 electors in the Electoral College. Each state has a number of electors equal to its number of representatives in the House, plus its number of senators in the U.S. Senate. California currently has the most electors because we have the biggest population and we have the most representatives in the House. So it makes sense. 435 members of the House plus 100 members of the Senate gives us 535 votes. However, I said there are 538 votes in the Electoral College. Those additional 3 electors come from the District of Columbia. And that was an addition back to the Constitution that added 3 electoral votes to the District of Columbia. We did that back with the 23rd Amendment to the Constitution. So that's why we have 538 votes in the Electoral College. Essentially, what happens is that when you vote for a presidential candidate, you are actually not voting just for that presidential candidate, you're voting for that candidate's list of electors. And so every candidate that qualifies for the ballot in a state will provide the Secretary of State with its list of electors. And then typically for 48 out of 50 states, whichever candidate wins the popular vote in that state, their entire list of electors then get elected to the Electoral College. So if you win the District of Columbia, then you get all 3 of those electors. You win the state of Ohio, you get all 18 of its electors. You win California, you get all 55 of its electors. It's pretty much a winner-take-all system, with the exception of Nebraska and Maine. Nebraska and Maine apportion their electors based upon who won each congressional district. So you get an elector for a congressional district that you won, and then there's one additional elector provided for whomever won the majority of congressional districts within the state. So that's how Nebraska and how Maine do it. It's kind of an odd system. Other than that, the other 48 states currently do a popular vote, winner-take-all type of approach. So if you win the popular vote in the state, you get all that state's electors. 538 electoral votes means that you have to have 270 votes in order to win the Electoral College. We saw back in 2016 an instance where Hillary Clinton won the popular vote, but lost the electoral vote to Donald Trump. We oftentimes see the electoral vote coincide with the winner of the popular vote, but sometimes it doesn't, like in 2016. Also in 2000, between Gore and Bush, we saw Al Gore win the popular vote relatively handily, but lost the Electoral College vote by 1 vote to George Bush, and that was essentially Florida. So that's our Electoral College, a relatively unique type of institution that you don't see in many other countries around the world. I do think there is a compelling argument that the Electoral College doesn't really function today in the same way in which it was envisioned by the framers. The framers really envisioned these electors as being people who were very well versed in politics, people who really understood the system, highly educated, kind of like the same type of people who would be serving in the federal government at that time. Today, our electors are essentially those who are beholden to a candidate. They are oftentimes and almost always party loyalists. And so the political parties really do control our Electoral College today, far more so than I think the framers ever envisioned whenever they established the Electoral College. So that's how you get elected to be president today. There are a lot of things here in Article 2. I know we're already up to an hour of discussion so far, so let me just hit some of the highlights. There are many roles that are provided to the president in Article 2 of the Constitution. Some of the roles that are provided to the president in Article 2 are things such as commander-in-chief. It was very important for the framers to have a civilian in charge of the military. In addition to being commander-in-chief, the president is also, you can make an argument, chief diplomat, in that the president is given the opportunity and the ability to enter into treaties with foreign nations with the advice and consent of the Senate. That's something that when George Washington entered into his first treaty, he actually hand-delivered the treaty to the Senate for their consideration, and then sat on a bench outside the Senate chambers waiting for them to approve that first treaty. He sat there for 2 or 3 hours, and so eventually someone came out and said, it may take us another day or two before we're able to approve this treaty. And Washington was angry because Washington thought it would just be a rubber stamp of the treaty that he entered into. He stormed away from the Senate chambers, and he never returned to the Senate again throughout the rest of his administration. because the Senate really asserted itself and said, we're going to consider this. We're going to debate this. We're going to have a dialogue over this before we actually approve this treaty. Presidents are also chief executives in that presidents can appoint people to the federal bureaucracy. Well, again, many of them with the advice and consent of the Senate. So the Senate must then confirm many of these appointments, things like appointments to the federal judiciary, appointments to the U.S. Supreme Court, top level appointments in terms of cabinet level appointments. Those are all approved by the Senate, but it does make the president executive commander or executive chief, in that the president has the ability to appoint these people for Senate consideration. The president is chief of state, and that the president has a responsibility of providing a State of the Union address that's here in Article 2 of the Constitution. The president must, at least once per year, give this State of the Union address. Doesn't say when they have to do it. Typically, it's become the end of January of each year to provide this update to Congress. That is a requirement under the Constitution. Presidents also have the responsibility for being what we call chief legislators, in that here in Article 2, one of the powers of the president is to recommend legislation to Congress. And so we always think about Congress does the legislation, the executive branch does the execution, but the Constitution, Article 2, actually tells us presidents have the ability to recommend certain pieces of legislation for congressional consideration. One interesting aspect here of Article 2 is the oath that a president must say. And you'll see here in this last paragraph, before he enter on the execution of the office, he shall take the following oath or affirmation. And there's the actual oath itself. There is a interesting situation back in the Obama administration that whenever Obama was being inaugurated, it's the Chief Justice who does the oath. And Chief Justice Roberts, when he was doing the oath to President Obama, screwed up a few words and had to restart the oath during the inauguration. He was adamant then that the next day he would meet President Obama in the Oval Office and re-administer the oath, because he felt that if it was not administered word by word as the Constitution says it should be administered, then it may not be a valid inauguration. So he actually had to redo the oath the next day in the Oval Office. We also know that presidents, vice presidents, and civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Now, this has always been controversial, this phrase, other high crimes and misdemeanors. Treason, bribery, those are pretty straightforward. However, what do the framers mean by high crimes and misdemeanors? That's an argument that we continue to have in terms of impeachment. What constitutes as a high crime? The word misdemeanor, as we use it today in our criminal justice system, is a minor type of crime, certainly below a felony offense. But that's not really the meaning of the term misdemeanor back in the late 1700s. Some constitutional scholars will say that the framers put the word misdemeanor in there because it came from English law, and they liked the word. They liked the way the word sounded, and it didn't really have the meaning of misdemeanor that it has in our current criminal justice system. But the powers and duties of the president are then laid out there in Article 2, again, not quite as long and not quite as detailed as Article 1. Then Article 3 is even shorter and far less detailed than even Article 2. In Article 3, we establish one court, and that is the U.S. Supreme Court. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish. So we have one Supreme Court. All the rest of the judiciary is established by Congress and was done so in the Judiciary Act. Whereas there are requirements to be a member of the House, you have to be at least 25, you have to be at least 30 to be a senator, you have to be at least 35 years old and a natural born citizen in order to be president. We kind of skimmed over that in Article 2, but you got to be at least 35 years old and you have to be a natural born citizen. Here in Article 3 with the Supreme Court, there are no constitutional requirements to be a Supreme Court justice. You don't have to attain any specific age. You don't have to be a citizen. You don't have to have a law degree or graduate from law school. None of that is required here in Article 3. For this U.S. Supreme Court, there are two different types of jurisdiction that are created in Article 3. There's what's called original jurisdiction and appellate jurisdiction. Original jurisdiction is when a case can start at the U.S. Supreme Court, when it can go directly to the U.S. Supreme Court. That is a very, very rare occurrence. Less than 0.00001% of cases get to the Supreme Court through original jurisdiction. To get to the Supreme Court under original jurisdiction, it must be a case that has momentous impact on the Constitution and something that is very time sensitive, that has to be decided immediately. That would be something that could go under original jurisdiction. 99.99999% of all other cases get to the court through appellate jurisdiction, whereby they are appealed through the federal judiciary. So they'll start at the district trial court level, then be appealed up to the circuit court of appeal, and then eventually appealed up to the U.S. Supreme Court. The vast majority of cases that are appealed to the U.S. Supreme Court are never heard by the Supreme Court. In order for the court to hear a case, they have to grant what is called a writ of cert. And a writ of cert is the Supreme Court agreeing to hear a case. Yeah, let me put that in there. It's a writ of certiorari, or otherwise known as a writ of cert. There aren't a whole lot of writs of cert that are issued by the court. The vast majority of cases, the court passes on and are then never heard by the U.S. Supreme Court. And so whatever decision was made at the Circuit Court of Appeals level then becomes permanent. Supreme Court really, in the past, has based a lot of its decisions on this judicial principle that I'm sure you've heard of, known as stare decisis. And stare decisis is basing decisions on precedent. And so the court will use precedent to make a lot of its current and future decisions. Now, the court has started veering away from precedent in some recent cases. So it's kind of unclear whether the court will continue to use stare decisis to make its court rulings. But only one court established in Article 3, and that is the U.S. Supreme Court. Now that the three branches of government have been established in Articles 1 through 3, we then move into Article 4. And one of the important things from Article 4 is what's called this full faith and credit clause. In Section 1, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. In other words, states must respect the laws of other states. So it's what's called giving full faith and credit. Citizens of each state are entitled to all the privileges and immunities of citizens in the several states. And so you have to be given the same privileges and immunities in the state of California as that you would be given in another state. No state shall be admitted to the Union except by Congress. And so Congress will decide if any new states get admitted to the Union. And if you remember a few years ago, we had a controversy here in California about, well, California is just too darn big. And so we need to break California up into 3 different states. And there was going to be an issue on the ballot where people would vote on breaking the state up into 3 different states. Well, that's all well and good, but those 3 quote unquote new states could not become part of the United States without the blessing of Congress. That Congress is the only one to allow new states into the Union. Section 4 is also important. The United States shall guarantee to every state in this union a Republican form of government and shall protect each of them against invasion on application of the legislature or the executive against domestic violence. So here is this protection that states are getting from this new national government, and each state must provide its citizens with a Republican form of government. Republican form of government, not meaning political party, but meaning that people have the opportunity to vote on who represents them and who makes decisions for them. Hence the reason why we oftentimes refer to ourselves as a democratic republic or a constitutional republic, as opposed to a pure democracy. And let me scroll back up here to Article 5. Article 5 then talks about how we amend the Constitution. Now, remember in our brief discussion of the Articles of Confederation, we said one of the major problems with the Articles is that you had to have a unanimous vote of all the states in order to amend the articles. So if you saw a flaw in the articles, you had to have unanimous agreement in how to correct that flaw. Well, the framers knew that was a problem. That's why they ended up with the Constitutional Convention to begin with. So here in Article 5, they lay out for us 4 different ways in which we can amend the Constitution. Now, even though there are 4 ways to amend the Constitution, we've only used approach number 1. We've only used number 1 of the 4. But the 4 ways to amend the Constitution, the first way is with a 2/3 vote of the House and the Senate. So an amendment may be proposed by a 2/3 vote of the House and the Senate, and then the amendment gets ratified by 3/4 of state legislatures. So 2/3 proposal in the House and the Senate, and then ratification by 3/4 of state legislatures. And that's the approach we have always used. However, there are 3 other possible approaches. The second approach is proposal by 2/3 of the House and the Senate, and then ratification by 3/4 of state constitutional conventions. So rather than having a state legislature ratify, we will have constitutional conventions in each of the states and have 3/4 of those conventions ratify, then it become an amendment to the Constitution. The third approach is to have 2/3 of the states petition Congress for a national constitutional convention. Then at that National Constitutional Convention, any amendments that come out of that convention would then have to be ratified by 3/4 of state legislatures. And then the fourth approach, 2/3 of the states petition Congress for a National Constitutional Convention, and then any amendments that come out of that Constitutional Convention then get ratified by 3/4 of state constitutional conventions. Now, you can kind of see why we've avoided numbers 2, 3, and 4. Because numbers 2, 3, and 4 all include some type of a constitutional convention. We know what happened at our original constitutional convention. The framers just met to amend the articles. They ended up throwing the articles out completely and replacing them with a brand new and much different constitution. And there's a concern that if we have constitutional conventions, a similar thing may happen. So the much more conservative approach is approach number 1. Amendment proposed by 2/3 of the House and the Senate, and then ratified by 3/4 of state legislatures. Then in Article 6, the most important part of Article 6 is that middle paragraph. The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. So this is the Supremacy Clause. Supremacy Clause is a very strong declaration of national government power. So whenever a state constitution or a state law comes into conflict with a national law or the national constitution, the national level wins. The Supremacy Clause obviously was something that the Federalists really favored. The Anti-Federalists weren't crazy about. And so because of the inclusion of the Supremacy Clause, that's one of the reasons why we ended up getting the 10 amendments to the Bill of Rights to try and mollify those concerns on the part of Anti-Federalists. And then Article 7 talks about how this new Constitution gets ratified. Constitution, in order to get ratified, must be ratified by 9 out of the 13 states. We said that happened relatively quickly. We ended up getting 10 states to ratify the Constitution within about a year and a half. The problem was we didn't have New York. And that's why we had the 10 amendments. And that's why we also had the Federalist Papers written by Hamilton, Madison, and Jay in order to convince the citizens of New York to ratify and accept the new Constitution. So that's the original Constitution, the 7 articles that make up the Constitution. But as we know, the Constitution is a living document that is changed from time to time. And we have made 27 amendments, 27 changes to this original Constitution. So now that we've dispensed with the 7 articles, let's take a look at these 27 amendments, because these amendments will have direct import upon what we do as public administrators and how we interact with the citizens we deal with on a daily basis. But before we do that, I know we've been at this for a while, so it's 5:15. Let's go ahead and take a break. let's come back at 5:30 and we'll finish our discussion of the Constitution. We'll go through the 27 amendments and then we'll see how much time we have left. And if we have enough time left at the end of class, we'll then get into our planned discussion of accountability and ethics. But we'll see how long our discussion of the 27 amendments take us. So 5:15, come on back at 5:30 and we'll do our 27 amendments to the Constitution. Okay, welcome back from break. Let's now move into our discussion of the amendments to the Constitution. And again, these have some direct applicability to what we do and how we interact with citizens. So we know the first 10 amendments to the Constitution are the Bill of Rights. They were passed in order to placate some of the anti-federalist concerns about creating too strong of a national government. So they were meant to reserve certain rights for people and to place some limitations on the national government and specifically limitations on Congress. So we're all familiar with the First Amendment to the Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So this is your two-part Establishment Clause and Free Exercise Clause. The Establishment Clause that says Congress shall make no law respecting the establishment of religion means that there cannot be a national religion. So it means people are free to believe what they want to believe. They are free to follow whatever religion they want to follow. That freedom to believe what you want to believe is basically unfettered. However, with the second clause, the Free Exercise Clause, there are some limitations to your free exercise of religion. And the Supreme Court has essentially said that whenever your free exercise of religion impedes upon the welfare of society or the freedom of someone else, that's where there can be some reasonable limitations to free exercise. So if religion calls for sacrifices in public, well, that's something that can't be done because that has a direct impact upon public safety. And so government can limit that as a free exercise of a religion. So whereas establishment is unfettered, there can be some reasonable limitations placed upon free exercise. Congress shall abridge, no laws abridging the freedom of speech or the press or the right of the people to peaceably assemble and to petition government for redress of grievances. Here again, there are reasonable limitations to some of these freedoms. We know the famous Supreme Court line of yelling fire in a crowded theater as a reasonable limitation on freedom of speech, because yelling fire in a crowded theater would then obviously place the public at harm. There can be some limitations on freedom of the press as well. However, in this country, we don't have what's referred to as prior restraint for the most part. A lot of countries will have prior restraint, which means that government can stop things from being published. We don't have a whole lot of prior restraint here in this country, but there are some limitations in terms of the press and how the press is able to cover events. And so again, if it's something that threatens public safety, something that threatens national security, then there can be some reasonable limitations tolerated on freedom of the press. The right of people to peaceably assemble, there are limitations associated with that as well. That if you want to go and you want to protest, you may have to get a permit from the city that will allow you to protest in a certain area, in a certain day, at a certain point in time. If you watch our national conventions, and there'll be 2 national conventions coming up in 2024, you'll notice that a lot of the protesters are kind of walled off into a separate area away from the convention goers. And again, that's done under the guise of public safety. So there can be some limitations placed upon your ability to peaceably assemble. Second Amendment, this is one we argue about a lot, and we're still arguing about today. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Obviously, we have an NRA that really reads it in terms of very broadly, the right of people to keep and bear arms shall not be infringed. We have others who read the well-regulated militia portion as an important part of the Second Amendment. a lot of people say we don't really know what the framers meant when they said a well-regulated militia, but if you do go back and read the Federalist Papers, there are a few Federalist Papers that speak directly to this idea of a militia, and specifically a well-regulated militia. And Alexander Hamilton in Federalist number 24 talks about what he means by a well-regulated militia, and talks about what he considers to be well-regulated, how often the militia needs to meet, how the militia needs to be equipped, the expectations for militia, that the expectations as members of a militia would not be like soldiers, in that you can't just go and drill once a month and then expect to be as proficient as someone who does it on a daily basis, but really specifically addresses this idea of a well-regulated militia. So because of the discussion of well-regulated militia in the Federalist Papers, it seems pretty clear that it was put there intentionally in the Second Amendment. But we always argue about the scope of gun control laws. There is a concept in constitutional law that's known as incorporation. Put that in text chat if I can type it correctly. Incorporation. Incorporation speaks to the extension of these limitations on national government power to include limitations on state governments as well. So the 10 Amendments, the Bill of Rights, were written primarily to be limitations against national government action. And in a series of Supreme Court cases after the founding of the nation throughout the 1800s, the Supreme Court really did take that interpretation of, well, these limitations are limitations that apply only to the national government. However, over the years, the US Supreme Court has continued to expand those protections to include state government action as well. And that expansion to include limitations on state governments is known as incorporation. Some of these rights have been fully incorporated to include state and local government limitations. Some of these rights have never been fully incorporated. Your right to bear arms in the Second Amendment to the Constitution has never been fully incorporated to the state and local level. That's why we see different gun control laws in different states and in different localities. The gun control laws here in California are much different than the gun control laws in Alabama. The gun control laws in Chicago are much different than the gun control laws in Montgomery. And so you can have differences between approaches at state and local government levels because this has never been fully incorporated to include all state and local governments. The Third Amendment is the quartering of soldiers amendment. No soldier shall in time of peace be quartered in any house without the consent of the owner. This is essentially a privacy right. This means that you have privacy to your home and you cannot be forced to allow soldiers into your home. So it kind of fits within this umbrella of privacy. Fourth Amendment, again, talks about privacy in terms of unwarrantable search and seizure. But the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. If you're a law enforcement organization and you want to search someone's house or search someone's possessions, you have to go to the court and you have to get a search warrant signed off by a judge of that court. Otherwise, it's considered to be an unwarrantable search and seizure. So this is one of your privacy protections. Fifth Amendment talks about some of your criminal justice protections, more criminal justice protections. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentation or indictment of a grand jury. So you have the right to be indicted by a grand jury before you can be brought to trial on these types of charges. No person shall be subject for the same offense to be twice put in jeopardy of life or limb. This is your double jeopardy protection, that you cannot be tried for the same crime twice. Now, this double jeopardy protection is something that people did not always have at the state level. And let me give you an example to illustrate that. In the 1930s, there was a very famous Supreme Court case, Palco versus Connecticut. And in the Palco versus Connecticut case, Mr. Palco was charged with murder. And the state of Connecticut tried Mr. Palco for murder. and did not get a conviction. Mr. Palka was found not guilty. The state was not happy with that verdict, and so they then turned around and retried him again. The exact same charge, the exact same evidence, just a different jury, and actually ended up convicting him the second time of murder. Palko complained to the Supreme Court, appealed all the way up to the Supreme Court, saying, this is a violation of my double jeopardy protections. I'm being tried for the same crime twice. The Supreme Court said, we are sorry, your double jeopardy protections only apply to the national government. They do not apply to the state level. They do not apply to the state of Connecticut. That right against double jeopardy had not yet been incorporated to include prohibitions against state government actions. It wasn't until the 1960s in a case called Benton versus Maryland, in which the court finally extended double jeopardy protection to include limitations against state government action as well as national government action. Didn't help Mr. Palko because it was 30 years too late. That's just kind of this example of how some rights took a long time to be incorporated to include limitations against state government action. So you have these double jeopardy types of protections. You have protections against self-incrimination. You cannot be forced to be a witness against yourself, and you cannot be deprived of life, liberty, or property without due process of law. These are your criminal justice protections. You have to be go through a trial, go through the entire criminal justice process before you can be deprived of life, liberty, or property. Also, private property cannot be taken without just compensation. This is where you get into in the local government level, things like eminent domain, where if the local government wants your property for some development project, they have to provide you with just compensation for your property. Continuing with some of your criminal justice protections, the Sixth Amendment to the Constitution, you have the right to a speedy and public trial. This has been in the news a lot lately with the indictments in Georgia, and we had some of those defendants in the indictments in Georgia who prevailed upon the state of Georgia to provide them with a speedy trial. And if you've been following the news, you know that in Fulton County, Georgia, there is a requirement that if a defendant asks for a speedy trial, then that speedy trial must be provided by the end of the next judicial session. And in Fulton County, the next judicial session ends at the end of October. And so therefore, for those defendants, their trials have been scheduled for October 23rd because they exercised their right to a speedy trial. Now, some of the other defendants are not exercised. They're not exercising their right to a speedy trial. They're waiving their right to a speedy trial. And so it's still unclear as to whether or not they will have to go to October 23rd trial date or if they can extend their trial date to some point in the future. You have a right to a trial by an impartial jury. That's a major tenet of our criminal justice process, in that you have the right to a trial by an impartial jury of your peers. You have the opportunity to confront witnesses who are being brought against you. You have the right to have counsel for your defense. And so through a lot of Supreme Court cases, we ended up with Miranda versus Arizona, which requires that people are informed of their right to counsel. And they must be informed of their right to counsel before they are questioned by police, because everyone has the assistance of counsel for defense. The Seventh Amendment is a right to a jury trial in civil cases where the amount of the case exceeds $20. Now, again, today, $20 is not what it meant in 1790s. And so it's a different type of situation for us, but you have a right to a civil trial, a jury trial in a civil case of more than $20. Oops, just move that again. Hold on one second. Make this page move for you. Okay. The Eighth Amendment, excessive bail should not be required, nor excessive fines imposed, nor cruel, unusual punishment inflicted. So no cruel, unusual punishment. Again, this has not been fully incorporated to include state prohibitions as well. That's why some states have a death penalty and some states use different approaches to capital punishment than other states use. There's a very famous Georgia Griggs case at the Supreme Court that reauthorized the ability of states to use capital punishment. Ninth Amendment, the enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Meaning that just because we have given certain rights to the national government doesn't mean that other rights are not still retained by the people. The other rights that are not mentioned in the Constitution are then reserved for the people. And then the 10th Amendment, which is a very big nod to the anti-federalists, says that the powers that are not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. This is what's known as the Reserved Powers Amendment. So any rights that are not given to the national government in the Constitution, those rights are then reserved and then belong to either the states or to the people. So this Reserved Powers Amendment really runs very much counter to the Supremacy Clause in Article 6 of the Constitution. And here are those compromises that create kind of a nebulous relationship between the federal government and state governments. And it's that nebulous relationship that we have been trying to interpret over the past 200 years. And sometimes the US Supreme Court will come down on the side of the national government. Sometimes they'll come down on the side of state and local governments. It really depends upon the issue, and it also depends upon the composition of the Supreme Court at that point in time. There's one really good example of that, not to digress too much, but there are a series of two cases, one case in the 1970s and one in the 1980s. The case in the 1970s, in 1976, was a case called National League of Cities versus Usury, or NLC versus Usury. And the NLC versus Usury case, we had state and local governments that were taking issue with a law passed by Congress. Congress had done an update to the Fair Labor Standards Act, the FLSA. And when they did this update to the FLSA, they extended minimum wage requirements to include requirements for state and local employees. Well, state and local organizations complained and said, we're sovereign entities. We should be able to determine how much we pay our employees. We should be exempt from the Fair Labor Standards Act requirement of a minimum wage. They took the case up to the Supreme Court. National League of Cities took it all the way up to the Supreme Court. And in NLC versus Usury, the Supreme Court agreed with local governments and said that, yes, we're going to provide you protection, that what you are doing in paying your employees is an essential function of government. And so Congress does not have a right to tell you as a local government or a state government how to carry out an essential function of being a sovereign government. So they provided them protections from this minimum wage requirement. That was in 1976. Then 9 years later, in a case called Garcia versus SAMHSA, and SAMHSA stands for the San Antonio Metropolitan Transit Authority. In this case, Garcia versus SAMHSA, it was the exact same case, the exact same details, exact same facts of the case. Once again, the Fair Labor Standards Act had come up for reauthorization in Congress. Congress, when they reauthorized it, again tried to extend minimum wage requirements to state and local governments. State and local governments said, we're going to complain about this. We're going to take this up to the Supreme Court because look what the Supreme Court said 9 years earlier. We should be protected from these minimum wage requirements. In Garcia versus SAMHSA, the Supreme Court came to the complete opposite conclusion. And in Garcia versus SAMHSA, the Supreme Court took the extraordinary measure of saying, we were wrong. When we determined that what you pay your employee is an essential function of government back in 1976 in the NLC versus Usury case, we were wrong. We are judges. We don't know what an essential function of government is. We don't do that on a daily basis. So we basically overstepped our boundaries by saying, yes, this is an essential function of government. And so what they did in Garcia is they said, we are sorry, state and local governments, we are not going to protect you from this minimum wage requirement. If you want to fight against this minimum wage requirement, don't come to us and do it in a judicial setting. You have to do it politically. You have to go out there just like any other interest group, and you have to lobby Congress for a political redress to your grievances. They essentially took what used to be a constitutional issue in 1976, and they redefined it as a political issue, saying this is something that belongs in the political arena. So that's just an example of how the Supreme Court completely changed its interpretation of the balance of power between national and state and local governments in a 9-year period of time. So these decisions are not necessarily set in stone. And so when the Supreme Court makes these interpretations, their interpretations will depend upon the era they're dealing with, the issue they're dealing with, and most importantly, the composition of those justices who are sitting currently on the Supreme Court bench. Okay, let's go through some of the other amendments. So those first 10 amendments, we initially amended the Constitution 10 times immediately with the Bill of Rights. But over the subsequent 200 odd years, we then also added on amendments in a piecemeal fashion. So we get the 11th Amendment to the Constitution, which essentially limits the judicial scope and the judicial reach of the national government, limiting the ability of the national judiciary to hear cases brought by a citizen of one state against another state. The 12th Amendment to the Constitution, well, it's jumping all over the place. The 12th Amendment to the Constitution, let me try and scroll up again. Almost there. And I can't go too fast or else it jumps pages. Here we go. The 12th Amendment to the Constitution comes to us courtesy of Thomas Jefferson. And originally, when we elected presidents, the person who came in first became president. The person who came in second became vice president. Well, there's an obvious problem with that, is that once political parties started to form, you ended up with the person winning the presidency being from one party and the person coming in second, becoming vice president, being of another political party. And we saw that in the Jefferson administration when Jefferson came in first and Aaron Burr came in second. Jefferson hated Burr and Burr hated Jefferson. They were from completely different political parties and they did not like each other, and they had really a personal affront with each other. And so Jefferson immediately wanted Congress to pass this constitutional amendment so that no longer would the person who comes in second become vice president. Essentially, the president and the vice president would run together essentially on the same ticket. And that's what we end up getting with the 12th Amendment to the Constitution. So no longer does the second place person automatically then become vice president. Then we have the 13th Amendment to the Constitution, which was ratified in 1865. The 13th Amendment outlaws slavery, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So slavery is outlawed as of the 13th Amendment. Then we have the 14th Amendment. The 14th Amendment is oftentimes referred to as the Equal Protection Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without the due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Then we get to section number 3, and this is one that you've heard a lot of talk about recently. No person shall be a senator or representative of Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, but Congress may by a vote of 2/3 of each state remove such a disability. In other words, if you have served in an office and you have taken the oath to the United States that everyone takes, even if you're a state or local employee, you'll end up taking an oath, and that oath will pledge allegiance to the United States to defend and support the Constitution of the United States and the Constitution of the state of California. Once you have taken that oath, if you engage in insurrection or rebellion, or if you provide aid or comfort to others who have engaged in insurrection or rebellion, you are then disqualified from holding any future office. Now, this is the one that a lot of people are talking about now as we move toward the 2024 election. The Secretary of State of New Hampshire, the Secretary of State of Arizona, and some other states are looking very closely at whether or not this applies to former President Trump. And that's an open legal question, but just keep an eye on it because it's something that's going to play out over the next several months to see whether or not there are any states to try and keep his name off of the ballot in 2024. I know there's a lot here and we're running short on time, so I'm going to go more quickly. The 15th Amendment to the Constitution, it says you cannot deprive the right to vote based upon race, color, or previous condition of servitude, ratified in 1870. 16th Amendment provides for a direct federal income tax. Now, remember in our discussion of the original Constitution, there were apportionment provisions that said that taxes must be apportioned according to state population. The Congress tried after the Civil War to try and implement a direct federal income tax directly on the incomes of individuals. It then tried to do it again at the turn of the century. The problem with that is that when you apply a direct tax to an individual's income, you are violating the apportionment clause of the Constitution. You're not taking state population into account. And so to get around that, whenever an act of Congress is considered to be unconstitutional, Congress can get around it by proposing a constitutional amendment. And that's exactly what they did here with the 16th Amendment to the Constitution. The Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. So you can have a direct federal income tax on individual income. So today you'll still hear people say, don't pay your federal income tax because it's unconstitutional. That would have been true before February 3rd, 1913. After February 3rd, 1913, Congress may levy taxation on any source whatsoever without apportionment. So the federal income tax is indeed constitutional today. So pay your taxes. I guess that's what it boils down to. The 17th Amendment to the Constitution looks at the election of senators. Remember, under the original Constitution, senators were selected by state legislatures. Here in the 17th Amendment, we make for a direct election of senators by the people. So now the Senate then becomes directly elected by voters. 18th Amendment is prohibition. So prohibit the manufacture, sale and consumption of liquor. The 19th Amendment is women's suffrage. So the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. That was ratified August 18th, 1920. It's important to note that there were several states that provided women's suffrage many, many years and decades before that. States like Oregon, states like Wyoming had women's suffrage long before it became part of the national constitution. Again, that was to try and attract population into those sparsely populated states. 20th Amendment to the Constitution changes the terms of office for president and Congress. Under the original Constitution, the president and Congress would take office in March. Under the 20th Amendment, we then shift those terms to begin in January. There's just too much of a delay between the election in November and the beginning of office in March. So we moved the beginning of office up to January. 21st Amendment then repeals, the 18th Amendment repeals prohibition. 22nd Amendment then establishes term limits for the president and puts a term limit requirement on presidents. This is as a result of FDR being elected to 4 terms in the presidency. He didn't finish his last term, obviously he died in office, but was elected 4 times to the presidency. So we went back to the Constitution and we put a 2-term limit onto presidents from the 22nd Amendment. Then the 23rd Amendment then provides the District of Columbia with 3 electoral votes. That's why we have 538 electoral votes as opposed to only 535. 24th Amendment to the Constitution eliminates what are called poll taxes that were used in a lot of southern states to try and disenfranchise Black voters. Those poll taxes were then eliminated, declared unconstitutional by the 24th Amendment. 25th Amendment is another interesting one in that we've had a lot of discussion about the 25th Amendment in recent years, and it speaks to presidential disability. So what happens if the president becomes disabled and no longer capable of carrying out their duties as chief executive? If that happens, then the vice president can meet with the cabinet, and the vice president, along with the majority of cabinet members, can then declare the president unable to carry out their duties as president, at which time the vice president then takes over the duties of the president and will retain those duties until the president is able to then reassert their ability to be president. Another avenue the vice president can use is a vice president can work with a committee of Congress and the Congress can put together a committee. Vice president can work with that committee in order to then declare the president unable to carry out their duties as president. But it gives us a way in which if the president is disabled and not able to carry out their duties, a way in which that person can then be replaced by the vice president. 26th Amendment to the Constitution allows 18, 19, and 20-year-olds the right to vote. So expands suffrage to 18, 19, and 20-year-olds. And let me scroll back down again. I don't know why it shot all the way back up there, but here we go. 24th, 25th, 26th. And then finally, the 27th Amendment, my personal favorite, just because of the process that it took to get this 27th Amendment ratified. 27th Amendment says that no law varying the compensation for the services of senators and representatives shall take effect until an election of representatives shall have intervened. In other words, members of the House and the Senate cannot take advantage of a raise in their salary until there has been an intervening election. So what James Madison wanted to do here is he wanted to make sure that people are held accountable by the public before they are able to take advantage of an increase in their salary. The 27th Amendment, you'll notice, was originally proposed in 1789. It was originally proposed with the Bill of Rights. So it was supposed to be one of the 11 amendments in the Bill of Rights. However, this one never got ratified by 3/4 of states. It also did not have what we call a sunset provision, and that there was no provision that it would become inoperable if it wasn't ratified by a certain date. Today, with amendments, we always have sunset provisions where we'll say if it doesn't get ratified by 3/4 of states within a 7-year period of time, it's considered null and void. Back then, we didn't have that in amendments. And so this amendment just kind of laid there and remained viable for a couple of 100 years. A student in Texas wrote a paper about how this was still a viable amendment because there's no sunset provision in it. I think got a C- on the paper or something like that, but it didn't deter him. He went out there and put together this committee and raised money to go around the country and try and get the remaining states to ratify the Constitution, the constitutional amendment. And lo and behold, by May 7th, 1992, 3/4 of states had ratified this amendment, and it became the 27th Amendment to the Constitution. So it's a really interesting situation that it was written and proposed by James Madison in 1789. That becomes part of the Constitution in 1992. So over 200 years later, became part of the Constitution. So those are the 27 amendments to the Constitution. Again, many of them speak to the rights and the powers that are retained by the people and the rights and powers retained by state governments as inherent limitations placed upon the national government. A lot of them speak to expanding those rights and expanding those privileges to citizens, regardless of race or regardless of gender or national origin, that kind of expanding that equal protection to all Americans. Again, most of these rights have been incorporated to include state and local governments. Not all of them have ever been fully incorporated. So the ability of state and local governments to have their own laws and have their own approaches on these issues will depend upon which right you were talking about and how fully incorporated that right has been. So in all my classes, I like to ask the question of, so what? So we spent about, 2 hours. We spent almost 2 hours talking about the Constitution, the 7 articles, the 27 amendments. Again, so what? It's important for a couple of reasons. One reason why it's important is because there's not really any other forum or venue whereby you can cover the Constitution in this program. This is probably the only time you're going to be covering the Constitution. So it's important that we take adequate time so that everyone is familiar with what the Constitution says as the social contract between us who work in government and the people that we serve. And secondly, it's important because we as public administrators have this standard known as qualified good faith immunity. Qualified good faith immunity says that we are largely immune from prosecution as long as we are protecting the rights of citizens and respecting their constitutional rights. So as long as we're acting within the course of our duties and we are not violating constitutional rights within the course of our duties, we have this qualified good faith immunity. So it's important for us to always remember that these powers and these liberties that people have in the Constitution are things we need to be aware of as public administrators, and then we need to endeavor not to violate those powers, those rights, and those liberties. So it's important for us as public administrators to have a working understanding and a working knowledge of the Constitution as this social contract between governments and the people that those governments are serving. So that is our coverage of the Constitution. And obviously, if we are following the Constitution, if we are acting as to not violate the rights of people we come into contact with, then we certainly have a much better opportunity to engage in our duties and carry out our duties in an ethical manner, which then leads us to our second topic for this evening, which is ethics and accountability. You'll see when we get to the ASPA Code of Ethics, one of the primary principles in the ASPA Code of Ethics is to know the Constitution and to not violate individual rights that are embodied within that Constitution. That's one of the specific code of ethics in the ASPA Code of Ethics. So let's spend about half an hour or so talking about accountability and ethics and talking about why sometimes they're difficult to implement and what we can do to better implement them and to hold our administrators more ethically accountable. Because after all, they are dealing with members of the public and they are dealing with public taxpayer money. So it really does put administrators in what we call a fiduciary type of responsibility, and that they are managing money that does not belong to them. So what is accountability? Accountability at its most basic level is this relationship between people and things. So relationship between administrators and money, relationship between administrators and organizations, between administrators and the public, between administrators and buildings and supplies. So it's always a relationship between people and the things that they are managing. It is the foundation of a bureaucracy because accountability allows policymakers to then control and hold accountable administrators for the actions that they are taking. You can kind of look at it as the connective tissue between policymakers, elected officials, and the administrators and the bureaucrats who are then executing those policies that have been passed by those elected officials. The problem with accountability is it oftentimes has this very negative association. Because when people think about accountability, they think about discovering problems. They think about finding instances where people are not being ethical, where people are not being accountable for the public money and public resources that they are managing. And oftentimes this means that even though accountability is this connected tissue between policymakers and policy implementers, policymakers oftentimes don't want to get involved. They want to try and keep their distance because when they get involved in accountability and ethics, then it creates this clear chain of accountability that makes them more accountable in return. That if they don't know a problem is happening and they never ask the question, the problem's going on, they cannot be held personally responsible for that problem. But once they start asking and they start looking and they see these problems, they fear that they are then going to be held accountable by the voters for whatever type of graft or corruption or malfeasance that they're uncovering through their accountability mechanisms. So oftentimes policymakers want to take a hands-off approach to accountability and ethics. But it's important for us to try and strike this balance of controls for administrators so that we can control their actions, but also allow them the flexibility they need to get their jobs done and to do their jobs well. Because at the end of the day, what we hope administrators will do is that they will be doing their jobs in an efficient and an effective manner and meeting the wants, needs, and desires of the citizens that they are serving. So it's this really difficult balance, this delicate balance that we have to try and find. If we err too much on the accountability side, then we're going to inhibit bold action and inhibit creativity and the ability of people to, I hate to say think outside the box, but think innovatively and creatively about solutions and how they do their jobs. And it's also going to make it difficult for us to attract administrators to the public service. If we have too many accountability measures and too many quote unquote hoops that people need to jump through, people are not going to want to work in the public service. They're going to opt to stay in the private service, and we're going to miss out on some of the best and brightest that we really do need in the public sector to make the public sector as effective and efficient as possible. So let's really drill down into this idea of accountability. And what do we mean when we say we're holding people accountable, and this idea of accountability between people and things? There are essentially three different approaches to accountability that we typically use in our ethical approaches in the public sector. One approach to accountability is what's known as the legal approach. The legal approach grows out of Woodrow Wilson, his Study of Administration article from back in 1887, and really grows out of this thing he called the politics administration dichotomy. Now, in a couple of weeks, you will read the Woodrow Wilson article, and you'll see how it really formed the basis for our study of public administration. But in the article, Wilson advocates for this thing called a politics administration dichotomy, whereby he says there's a political side of the equation and an administrative side of the equation. On the political side of the equation, we have policymakers and elected officials who make laws. They're the ones making the laws, they're the ones making the policies. And then on the administrative side, we have bureaucrats and administrators who then execute those policies. They then carry those policies out. So the ethical approach you would take in this legal approach to accountability is that if administrators are only operating only on the administration side, then that's okay. They're doing their job. However, when you have those administrators who kind of bleed over to the political side and start getting involved in politics, that's where we have our ethical violations. And that is a problem for ethics and accountability. So it really looked at this sharp, bright line division between the political side and the administrative side. Administrators administer programs, politicians that make those programs and make those policies. And then there's a clear dividing line between the two. What we realized relatively quickly after the Wilson article in the early 1900s is that there was no bright line demarcation between politics and administration. And as John Gauss tells us, that laws are not always clear. They're not always written in a way in which they can be immediately implemented. And oftentimes administrators need to translate those laws and those policies into something that they can actually implement. And so there is a bleeding over from the administrative to the political side of the equation. Administrators sometimes do have to get involved in the political world in order to be able to translate these very amorphous and very vague policies into tangible, specific approaches that can be used for policy implementation. So the political approach of John Gauss and others in the early to mid 1900s really recognized that you can't have this bright line legal definition between politics and administration. And that's not a way in which you hold people accountable. That we can assume that administrators will be getting involved in politics in order to translate these policies into measurable types of implementation outcomes. Today, the approach that we take in terms of accountability and ethics is a realization that accountability and ethics are much more issue-based and contextually based than in the previous two approaches. Today, we understand that every agency is different, that every agency will have its own organization culture, that every agency will have its own norms and values and expectations and codes of conduct. And it's not something you can apply across the entire federal bureaucracy or apply across the entire state bureaucracy. But instead, what you need to do is you need to take into account the uniqueness of the situation, those who are engaged in the process of administration, and those specific agencies in which they are in, and take all that context of the situation into account in holding people accountable for their actions. Essentially, there is no magic bullet to ethics and accountability. And the most appropriate way to hold people accountable is by finding this balance between external controls and internal controls within agencies. And if you can find that balance between external rules and internal approaches, that's how you can best assure ethics and accountability. So it's a much more complex, much more complicated way of viewing ethics than it was back in Woodrow Wilson's time. So when we are taking this contextual view of ethics and accountability, there are three different elements of accountability that we usually look at when we are holding people accountable for their actions. The first approach is the one that is most common, and that's what's called fiscal accountability. In fiscal accountability, we hold administrators accountable for how they spend monies on the programs that they are charged with. So how are they spending their money? Are they spending the money in the legally appropriated manner that they are supposed to spend that money? So are they spending the money in accordance with the rules and the laws and the regulations that govern how that money should be spent? That fiscal accountability approach is by far the most widespread way that we hold people accountable for their actions, by looking at how they are spending the resources that they have been entrusted with. So it's a fiscal accountability type of an approach. A second way in which we hold people accountable for their actions is in process accountability, whereby we hold people accountable based upon how they are performing their tasks and how their agencies are performing their tasks. This looks primarily at implementation. So we hold them accountable for how they are implementing these programs that they are carrying out. So we look at the implementation of the programs. And then the third approach is program accountability. This is where we look at the outcomes of the programs. Are the programs that they are implementing achieving the outcomes as defined by law? Are they achieving their goals and objectives as laid out in their enabling legislation? So we are holding people accountable. We can hold them accountable in a fiscal way, how they're spending the money, in a process way, how are they implementing these programs, and in an outcomes approach in terms of program accountability, how well are they accomplishing the goals and objectives that are supposed to be accomplished through the implementation of these programs and these policies. So accountability is a multifaceted, multi-dimensional type of term. It can be fiscal, it can be process, it can be program in nature. So how do we do it? How we do it is, again, by finding this balance, striking this balance between external rules and regulations and internal factors such as the character and training of our administrators. It's one thing just to have a code of ethics and then to tell our employees on their orientation day, here's the code of ethics, don't violate the code of ethics. It's another thing altogether to then train people, hire the people who really believe in public service and have the character to do things in the quote unquote right way, but also to train those administrators so they know how to do things in the right way. They know how to spend money appropriately. They know how to follow the processes. They know how to best accomplish the outcomes of a program. So it's really that balance of the external with the internal. And in balancing the external and the internal, we really need to empower people who are closest to the situation. So the people who are able to recognize violations of ethical principles are people who are within the agency implementing these programs on a daily basis. We need to empower these people to be what we call the whistleblowers. They need to be the voice of the organization. They need to be willing and able to point out ethical violations and problems with policies and approaches that they see within their organization. If we empower and protect those whistleblowers, they can really be the voice of ethics from within the organization. If we do not empower and protect them, they're going to exit the organization. They're going to just leave the organization and go elsewhere, and the problem will never get resolved. So one important linchpin here is whistleblower protection, that we provide the right set of protections to whistleblowers so they are comfortable pointing out these problems and bringing these problems to light. In 1990, we had this thing called the Whistleblowers Protection Act. The Whistleblowers Protection Act made it illegal to have reprisals or retributions against whistleblowers in our organization. So if a whistleblower blew the whistle on some ethical violation, and then there was some adverse job action taken against them, they were then able to take their case to the Office of Special Counsel. The Office of Special Counsel then would investigate it, and if truly they had some negative job actions taken against them, then they would receive benefits. They would then get that promotion that they were denied, or if they were denied some advancement in pay or reclassification, they would get that retroactively. And so the OSC, the Office of Special Counsel, would make these whistleblowers whole and protect them in their positions. Without proper whistleblower protections, it's not going to be possible for us to know these ethical violations and then be able to address them appropriately. We know the standards of ethics in the public sector are oftentimes higher than in the private sector. And oftentimes there's this shock of ethical upgrade when people go from the private sector to the public sector. In the private sector, you're managing private money. So certainly there are ethical standards that you need to adhere to, but you're oftentimes being held accountable to shareholders and stakeholders in a corporation. In government, you're working for the people. And so the people are your stakeholders. And so those ethical standards tend to be heightened because you're dealing with public resources as opposed to private resources. The problem is when we have too high of ethical standards and we have too many accountability mechanisms that people must adhere to, it makes it difficult for us to attract people from the private sector. It makes it difficult for us to attract the best and the brightest into the public sector. So we really need to be a voice to the ethos of public service. Yes, there are more accountability mechanisms. Yes, there are more hoops that you have to jump through when you are spending money or when you're implementing a program, but it's for a good purpose. It's because public service is seen as a higher calling. And what George H.W. Bush said, government service should be the highest and noblest calling. And Barack Obama in his 2008 campaign said that his goal was to make government and public service cool again, and that people need to have this public service ethos and really understand that it's worth it to follow these additional accountability mechanisms because you're doing public service, you're doing the public good. Charles Goodsell, back when he wrote The Case for the Bureaucracy many years ago, back in 1970, said that people have this very negative connotation that they associate with the bureaucracy. And it's usually because of their last interaction they've had with the bureaucratic organization. If they had a negative experience with the bureaucratic organization, they're going to think that all bureaucracies and all bureaucratic organizations are inefficient and are impersonal and are just full of rules and regulations. So what we need to do as administrators is we need to sell to the public how important public service is and how government really does touch every single aspect of their life, and how government really can make a difference in their lives and really can have an impact upon the quality of their life. So there is this ethos of public service that if we hire people into the public sector who share this ethos of public service, then it's going to be much easier to hold them accountable for how they're spending money, how they're implementing programs, and how they are achieving goals and objectives. The American Society for Public Administration has its own professional code of conduct that all administrators are expected to follow, regardless of level of government or agency or organization that you are working in. These elements of the ASPA Code of Conduct are relatively general in nature, but I think that they can be very instructive for us in understanding how we are expected to behave as public employees. So there are 8 different principles in the ASPA Code of Ethics. The first principle is public interest. Promote the interests of the public and put service to the public above service to oneself. This really is that public service ethos, and this really is what sets apart the public sector from the private sector. We are really very much promoting the interests of the public above our own individual interests. So as we're all rational self-interest actors, obviously, but the public interest really is above our own individual rational self-interest. The second one is the reason why we spend almost 2 hours talking about the Constitution. To uphold the Constitution and the law, respect and support government constitutions and laws while seeking to improve laws and policies to promote the public good. We need to understand constitutions, respect those constitutions, and support those constitutions and laws, while always having an eye on how to improve them and how to make them better, how to make them more equitable to everyone in society. The third principle is to promote democratic participation, to inform the public and encourage active engagement in governance. Be open, transparent, and responsive, and respect and assist all persons in their dealings with public organizations. We need to encourage people to participate in their own self-governance. We need to be as open and transparent and responsive as possible in doing our daily jobs. That's why we have sunshine laws like we have here in the state of California, where the public work is done in the open, where the public can see how their money and how their resources are being spent. Number 4, to strengthen social equity. Treat all persons with fairness, justice, and equality, and respect individual differences, rights, and freedoms. Promote affirmative action and other initiatives to reduce unfairness, injustice, and inequality in society. The promotion of social equity and promotion of social justice is a major value of public administration, and it continues to become more and more prominent with each passing year. Number 5, to fully inform and advise. And this is a tough one, but to provide accurate, honest, comprehensive, and timely information and advice to elected and appointed officials and governing board members and to staff members in your organization. This really brings up this idea of what's called the principal-agent relationship. And if you haven't heard about the principal-agent relationship yet, it is a major concept within the ethics literature. And I put that in text yet. The principal-agent relationship. The principal-agent relationship, you have a principal and you have an agent. The principal is charged with overseeing the actions of the agent. You would think that the principal, because they are in charge of overseeing the actions of the agent, that the principal would have the information. They would have the information that they need in order to oversee the agent. The problem with the principal-agent relationship is we have a lot of information asymmetry, in that it's oftentimes the agent that has more information than the principal. It then becomes up to the agent to decide what information and how much information to give to the principal that will then allow the principal to scrutinize and oversee what the agent is doing. So there's always this rational, self-interested type of motivation to not provide all the information to the principal so that they cannot scrutinize you too heavily. That's this problem with the principal-agent relationship. That's what's known as a moral hazard. The moral hazard is the agent has the information, but it would oftentimes behoove the agent to hold back that information because it then reduces the ability of the principal to hold them accountable. As administrators, we need to try and overcome that moral hazard. We need to fully inform and advise. We need to provide the accurate, honest, and comprehensive information that will then allow elected officials and appointed officials to conduct the oversight of our actions as administrators. It's a difficult thing to do, but it's something that ethically we are required to do under the ASPA Code of Ethics. Principle number 6, to demonstrate personal integrity, to adhere to the highest standards of conduct to inspire public confidence and trust in public service. If we are not following these ethical standards, then obviously we are going to erode the trust that the public has in us. We've seen what happened to the trust in the Supreme Court with a lot of these ethical questions that have arisen from the Supreme Court in recent days and months. And you see what happens in terms of public trust. Number 7, to promote ethical organizations. Strive to attain the highest standard of ethics, stewardship, and public service in organizations that serve the public. And then number 8, to advance professional excellence. Strengthen personal capabilities to act competently and ethically and encourage the professional development of others. It's not only incumbent upon us to be ethical and to develop as administrators, it's also important for us to help others to develop and to develop their own public service ethos and to develop their ability to behave ethically. And so it's always important for us to help the newer generation, the younger generation, to acclimate into the public sector. Those are the 8 principles of the ASPA Code of Conduct. Again, what I'm asking you to do is in our second graded Canvas essay that I believe is due on the 18th, you will be selecting 3 of these that you think could be relatively difficult to implement in your organization and talk about why they may be difficult. I think for a lot of organizations, the fully inform and advise because of the principal-agent relationship is somewhat difficult for a lot of organizations to try and implement. I think a lot of organizations, people who work in organizations are not really, even though they take an oath to the Constitution, are not really aware of what's in the Constitution and don't really have a lot of knowledge about the Constitution. And that's why, tonight is a very important part of your time in the MPA program, because you've now gotten this introduction to the Constitution so that you can then abide by standard number 2. Promoting democratic participation. Sometimes that's almost counterintuitive for some agencies, because the more they open their doors and the more they invite the public into their operations, the more scrutiny they're going to get. And sometimes that slows down the process and that delays the decision-making process, but it's something that needs to be done in order to abide by the ASPA Code of Conduct. Speaking of openness and transparency, we live in the state of California, and the state of California has some of the most stringent transparency and open government rules and laws of any state in the country. So the work that we do here in California is always open to public review and public inspection. We have laws in the books that require us to be open in our decision making. We have things like the Brown Act and the Green Act, and that these require open meetings. And if you have a majority of a body that is meeting, that meeting must then be open. There are agenda posting requirements, and then agendas need to be posted at least 72 hours in advance. There are requirements for how issues are dealt with in meetings. I spent 6 years serving on a local school board, and we always work very hard to try and stay in compliance with the Brown Act. When I joined the board, there wasn't a whole lot of compliance with the Brown Act, and I tried to make sure that we complied with every aspect of the Brown Act, and that any decisions and any conversations that were being undertaken by a majority of the board were always being done in open public session, and that you weren't having emails or phone calls bouncing back and forth between members of the board. We have a very open public records process here in the state of California as well. And if you've ever had to respond to a public records request, you typically have about 10 days in order to respond to that public records request. And a large amount of information is discoverable. There's a very famous case a few years ago called the San Jose case, which says that not only are emails discoverable, but text messages on your cell phone that have anything to do with the jurisdiction, have anything to do with the organization, that your text messages on your cell phone may be discoverable as well. And so it's really important that agencies, when they receive these public records requests, within 10 days, provide all this information that's being requested. And it's a very, very open process in that it doesn't take a whole lot for someone to put in a public records request. They could just simply send an email and just saying, I want to get access to all the information, all the correspondence that dealt with this contract. And then the district or the city would then have to produce all that information, all that correspondence, as long as it wasn't privileged. Conflict of interest forms. Some of you may be in reportable positions. If you're in a Form 700 reportable position, you need to fill out a conflict of interest form. That conflict of interest form will then require that you disclose any financial interests that you have within the jurisdiction in which you are working or serving. And it's a way in which you can then alert the public to, here's a potential conflict of interest, so that once that issue then comes before the board or the city council, you would then have to recuse yourself because that's a potential conflict of interest. And at least it alerts the public as to any potential conflicts of interest in the future. So there's a lot of transparency and openness that's required here in California. I've long been an advocate for us putting together an elective course on some of these requirements that we have in California for transparency and openness, because there are so many requirements, you could fill up an entire 15-week semester with all those requirements. But we are a very open, let the sun shine in type of state as compared to many other states in the country. So this exposure to accountability and ethics is just the beginning here in this class. You are going to cover accountability and ethics throughout all of your core courses as you go through the remainder of the program. But just as your takeaway from our brief discussion tonight, accountability in the public sector really does require striking this balance. We need to strike the balance between external rules and regulations and then the internal training of people within our organizations. If you don't have both of those parts of the equation, you're not going to be able to hold people accountable for their actions. We need to have bureaucratic responsibility and we need to have ethical administrators. But at the same time, we also need administrators who are freed up to take risks and to make good types of decisions where they don't feel that they're being boxed in by these ethical requirements and they are willing to make these creative types of decisions, that they're not going to be penalized for making a creative or an innovative type of decision, so trying something new. When we have too many accountability requirements and not enough freedom for people to make creative decisions, it makes it difficult for us to recruit the best and the brightest into the public sector. So again, we really need to try and balance this ethical adherence with effectiveness. Yes, we have to hold people accountable for their ethical behavior, but we also have to free them up to be as effective as possible. Because at the end of the day, our job in the public sector is to meet the demands of the public. And if we are following rules just for the purpose of following rules, that's one of the bureaucratic dysfunctions that we know in the public administration literature. Literature tells us that as organizations age, as organizations get larger, they tend to develop more and more rules and regulations. And then the goal of the agency becomes adhering to those rules and regulations as opposed to the goal of meeting the needs of the public. And once that happens, you have a dysfunctional organization. So again, the moral of the story here is it's all about balance, having the right amount of ethical adherence rules and then the right amount of flexibility that we give to our administrators in order to be as effective as they possibly can be. But if you don't have that training of your administrators, you don't have that internal impetus for ethics within the organization, all the external rules and regulations won't do you a bit of good. So you really need to have the balance of the external as well as the internal. I know we've covered a lot of information tonight and it's past 6:30, so I don't want to keep you any longer, but are there any basic questions about this material that we've covered relatively quickly on accountability and ethics? Again, this is just your first bite of the apple, and you're going to get a lot more of this as you go through the program. I would just ask that you pay close attention to these 8 principles in the ASPA Code of Conduct, because again, this will form the basis for your second Canvas essay that I believe is due on September 18th. But do remember, you have your initial skills self-assessment that is due on September 11th, and then you have Canvas essay number 1 and responses to 2 classmates also due on September 11th as well. Next week, when we get together, we will devote the vast majority, if not all of our session, to Kelly Janicek. And she's our disciplinary librarian for political science and public administration. She will be coming into our Zoom session. I'll turn the session over to her. She will walk you through how to use electronic databases, how to do research in public administration using the databases we have here at Long Beach. She'll do that in the first half of her presentation. Then the second half of her presentation, she will then talk to you about APA format, take you through how you cite different types of sources in APA 7th, because APA format is something that you're going to be using in all your courses throughout the entire MPA program. All right. Okay, if there's nothing else, then we will call it an evening. I'll get this recording up onto our Canvas site no later than tomorrow morning if you want to go back and review it. And then we'll be back at it again next Tuesday, again with Kelly Janicek and her library presentation. Okay? Thanks, everyone. Have a good remainder of your week, and I'll talk to you again next Tuesday. Thank you.
Thank you. Bye-bye.